sponsored by the AdLit project, which is an interdisciplinary research project focusing on children's advertising literacy in the new media environment. So within our project, we have different disciplines. I don't know. Voilà. So as I said, we are an interdisciplinary research project with different universities in Flanders, researching different topics, including law, education, science, marketing scholars, communication scientists, etc. And also throughout our project, we are trying to involve a broad variety of stakeholders, including regulators, policymakers, the advertising industry itself, academia, and we try to do this by developing different tools for all these different stakeholders. So we are developing educational programs, we are trying to create more awareness surrounding this topic, surrounding advertising literacy and children. And of course, we are also trying to give evidence-based policy recommendations for the regulatory framework and the self and co-regulatory framework. And this multi-stakeholder approach is also reflected in our panel, of course. So we have different representatives of different stakeholder groups. We have from academia, Professor Simone van der Hof, who is the director of the Center for Law and Digital Technologies at Leiden Law School, and also the program director of the Advanced Studies program in Law and Digital Technologies. Her particular academic interest is in the field of online privacy, digital child rights, and regulation of online child safety. Secondly, we have Joëlle Jouret, who has been working in the field of data protection for almost 10 years, and she's currently the legal advisor at the Belgian Data Protection Authority and primarily in charge of the practical implementation of the GDPR. Third, we have Patrick Geary, who is a children's rights and business specialist with UNICEF in Geneva, where he focuses on legal and public policy advocacy. And he has been an international children's rights advocate for over a decade and has worked for and with a wide range of companies, government institutions, and civil society organizations. Fourthly, we have our industry representative, Max Sørensen, who is an attorney at law and privacy officer at the Lego Group, and he works on marketing, IPR, and data privacy. But his focus point has been supporting the business with digital marketing projects, children's rights, and building the binding corporate rules privacy project for the Lego Group. Also achieving global GOBA certification. Then aside from our excellent speakers, we also have Professor Eva Lievens, who will introduce today's topic and who will act as our moderator. Eva is an assistant professor of law and technology at the law faculty of Ghent University and also a member of the Human Rights Center of the University of Ghent. And a recurrent focus in her research relates to the protection of minors in digital media, human and children's rights, and alternative regulatory instruments such as self and co-regulation.
Okay, thank you, Valerie, for the introduction of our panel. Just to give you an idea of the type of advertising formats that the AdLit project is focusing on, we have, too fast, some examples. And all these advertising formats are what we would call, well, maybe not new anymore, but hybrid digital advertising formats that are targeted at children. So, for instance, you see on the slide the use of influencers is something that is happening quite a lot and has a huge impact on children. This is happening with teenagers, but as you can see on the left-hand side of the slide, also with very young children who are opening toys and things like that, which has also a persuasive effect on children. Also, advert games, in-game advertising, toys, connected toys, that also may include brands in the conversations that they have with children. In that way, also trying to persuade them to buy certain products or services. And then, of course, the type of advertising that is most relevant to the discussion of today, and that is the personalized advertising. So the advertising that is targeted towards children based on their previous behavior, characteristics, emotions, and that is the topic more specifically of our discussion of today. All these advertising formats have some characteristics in common. The media content and the commercial content is often integrated, making it more difficult to distinguish between both of them. They are often interactive, engaging the child in the advertising format. It's often very entertaining, playing a game at the same time while getting the message, and of course personalization. So what is the starting point of, ooh, that was suddenly way too fast, I don't know. Yes. So let's just keep it like this. These characteristics ensure or lead to a situation where children often do not understand the persuasive effect or recognize the persuasive effect of the advertising message, which leads to difficulties in applying their advertising literacy skills. So advertising literacy, this means that first you recognize the message as being an advertising message, you understand the persuasive intent, and then you also are critical towards the message. So this may be much more difficult with these kinds of advertising formats. When we specifically focus on personalization, if these messages are adapted on the basis of characteristics, behavior, surfing, history, for instance, this might very well increase the effectiveness of the message, but there are, of course, also many issues in relation to the processing of the personal data of the child. And that's what we would like to talk about today. Within the project, we always try to adopt the children's rights perspective, and this is also what Simone will do in her presentation. So I'm very happy to give you the floor, Simone.
Thank you. When it works, it's quite difficult. Yeah. Sort of a magic wand. Okay, so what I will do is focus on the relation between the GDPR and marketing, and then at the end of my presentation also give a children's rights perspective on the GDPR and marketing.
I think we need to point to that.
Yeah. So what you do when it comes to the relation between the GDPR and marketing, well, traditionally the protection of personal data and protecting children against the harmful effects of advertising and marketing have been separate domains. But obviously with all these new developments that we have, and particularly also behavioral advertising, these domains start overlapping. And one of the key pieces of legislation that is important in that respect is, of course, the GDPR. Although the GDPR is essentially based on protection of personal data, it also recognizes that it is important to take into account the protection of personal data when it comes to commercial activities, amongst which marketing activities, and also more specifically profiling that can be used for commercial purposes. Oh, all of a sudden it goes just by itself. So what does the GDPR say about marketing, and particularly in relation to children? Well, I will go into the provisions in a moment, and some are more straightforward, but sometimes you really need to look more carefully in the GDPR to actually find out what it says about marketing. So let's go into that in a moment. But first, focus on sort of the key consideration in the GDPR when it comes to protecting children, which is recital 38. And which says that children need protection because they are less aware of the risks and consequences of processing of personal data, and also the rights that they have in respect of them. And this also sort of ties in with what we know from the advertising domain, which also focuses on the fact that children at certain ages are not able to recognize advertising, let alone to critically reflect on advertising. So we clearly see a relation there also with what we see in recital 38 when it comes to the processing of their personal data. So it's a matter of maturity, of knowing what is going on. The recital is also quite clear about that companies should refrain from exploiting that lack of awareness and understanding that children may have when it comes to what marketing is, how it works, and what the negative effects may be for them. So also it's important to note that marketing as such is not prohibited by the GDPR, but companies, and of course also other organizations, but I will focus on companies here, they need to comply with the rules of the GDPR, the general rules, because they also apply to children, but we have exceptions where there are specific rules for children, and overall in the GDPR you need to be very careful when you process the personal data of children. So let's go into some of the provisions, and I'll start with 2 lawful grounds in the GDPR, because you're only allowed to process personal data of adults or children when you have a lawful ground to do that. So that's one of the first steps you need to take under the GDPR. Well, in Article 8 of the GDPR, there is a specific rule for children, a much discussed rule already, but I won't go into that in more detail. I only focus on the marketing part there, which is about the age of digital consent. So under a certain age, children will need parental consent to use online services. And online services are defined as information society services, which is a concept that we've known all along in European legislation, and which basically means any commercial service that is offered on the internet. And of course, this includes also marketing activities. So Article 8 is also applicable when you as a company engage in marketing and advertising activities. More generally, this is not in Article 8, but in the definition of consent, there are some conditions when it comes to giving consent, and one of them is that it must be freely given. And that is also where something where we find some issues when it comes to marketing. Marketing is very often part of a package when using an app or an online service. And the marketing is not the core part of the app or service. So for instance, if you use Snapchat, it's a social media service where you want to engage with your friends and share photos, for instance. But marketing is part of that because that is what you're paying with. You're paying with your personal data. And when you look into the definition of freely given or how it's being interpreted, you will see that that is a package deal that is actually not allowed. So if the counterpart of the service is paying with your personal data, consent is not freely given. So for a lot of companies, that will be highly problematic. Freely given consent is also important in respect of, sometimes you're having different purposes with the processing of the personal data of children and adults equally. But for each of those purposes, you will need consent, separate consent, which also implies that these consents can obviously be withdrawn. So if you have the purpose of sending marketing messages, commercial communications, and there is also the purpose of sharing data with third parties, you will need consent for each one of those activities, one of those purposes. And of course, children must know what is happening with their personal data. And there we also have a specific rule that it must be understandable to children, but it must also be recognizable to them that this information is important to them and that it's meant for them. And preferably also be something that is appealing to them. So try to find ways of sharing that information, of explaining it to them that really also fit within the way they use the digital world. So maybe use videos and apps to do that, and not just text. lawful ground where that is important in relation to marketing is the legitimate interest. So companies can have a legitimate interest to process your personal data, and they need to balance that with the rights and the interests of the data subject. And in this case, there is a greater the rights and interests of children carry greater weight. So you need to be extra careful when you process personal data of children. Well, it seems to be clear that processing of personal data for direct marketing purposes to customers, so people you already have a relation with, a contractual relation with, can be covered by this lawful ground. And obviously here also the e-privacy directive that's going to be revised now holds important or specific rules. What may not be covered by, or what probably is not covered by the legitimate interest, is when you engage in consumer profiling, especially when sensitive information is involved, which can very quickly be the case, or sensitive profiles are involved, and when the process is intrusive in a sense that you're, for instance, engaging in producing predictive profiles and using those. And again, in this case, you need to be extra careful when it comes to children. So probably that is something that is not allowed under the legitimate interest ground. Then there are some provisions that directly relate to marketing activities. Very straightforward is Article 21, which says that data subjects, including children, have an absolute right to object to direct marketing. They can object at any time, free of charge, and they also can object to any direct marketing related activities that lead to profiling. This right of data subjects should be brought to the attention of data subjects very clearly. It should really stand out in the sense that you must separately communicate such information so they really know what their rights are in respect of them. So that also, again, raises challenges when it comes to children. And then, of course, maybe the most important provision when it comes to behavioral advertising is Article 22, which says, well, that data subjects, including children, have the right not to be subjected to decisions solely based on automated processing, including profiling, if that process has a legal or a similarly significant effect on them. Well, similarly significant effect, you could also, in case of children, think of advertising that holds harmful effects for them, because we know that some kinds of advertising do. They can make children unhappy, they can lead to unhealthy lifestyles, and so on. This article is not straightforward in the sense that it doesn't mention children, and there is quite some debate on recital 71, which is the consideration related to this article that does mention children, and that some people interpret as profiling not being allowed, so being prohibited in the case of children. That's not the way the Working Party 29 interprets the provision at the moment, at least. It's still a consultation, I believe. What they say, there is no absolute prohibition related to children, but the exceptions that are there in the article. So sometimes this profiling is possible when there is explicit consent or when it's necessary for the performance of a contract and when there are safeguards in place. But these exceptions need to be interpreted very restrictively when it comes to children, and you need to take, for instance, into account that the processing for these purposes must be in promoting their welfare or their health in a way. So you might think of profiling for the purposes of youth care. What is clear here is that the The idea that there should be no profiling for marketing purposes, which of course is important in relation to what we're discussing today. And what is also important that the WP29 the 29 Working Party says there should be codes of conduct on this rule specifically when it comes to children. So let's move briefly to the children's rights perspective because obviously the rules I've discussed here aim to protect children and obviously there are a number of children's rights that are relevant in respect of them. Well, the protection part is maybe quite straightforward in the sense that it is important to protect them against economic exploitation. So what I mean by that is that their personal data, so they're the product in a sense because their personal data is being used as payment for the service. So that would be something covered by, we argue, the right to protection against economic exploitation. But it's also important for their health and well-being because, like I said, marketing can make unhappy, it can lead to unhealthy lifestyles, and obviously it's important for their right to privacy. Maybe less straightforward is the other side of children's rights, which is, well, at least in the framework of the GDPR, often forgotten, it seems, and that is that children also have freedom rights and they have development rights. And we also need to factor them in when we interpret these rules. And because these rules are stricter for children than for adult data subjects, it can essentially lead to children being banned from apps and other online platforms. Because companies carry a great responsibility, especially when it comes to children, to be extra careful when applying the rules of the GDPR, and they may not want to have children on their platforms to sort of make sure that they're covered. Well, which leads, and for instance, and of course, for children, the internet is very important when it comes to information, when it comes to socially interact with people. So it sort of may violate the right to information, the right to access to media, the right to association, the right to development, a fundamental principle under the UN Convention of the Rights of the Child. And the other side is also that maybe paradoxically, well, you also need to make children understand what the context is in which their personal data is processed, which ties in with their right to education. And paradoxically, maybe at certain ages, appropriate ages, you should maybe also confront them with marketing for them to understand what it is and to learn how to critically reflect on that. When it is visible, that is, because a lot of marketing strategies are working unconsciously and it may not be the same there. So that is the empowerment perspective. And thanks very much for listening.
Thank you very much, Simone. I will now pass the floor to Jouret.
Thank you very much. Hello, everybody. I'll try to give the perspective of the Belgian Privacy Commission now on those points you just mentioned, Simone. If it works.
Yeah, you have to.
I have to wait a little bit, not too quickly. Yes. Right. Okay. Seems okay. All right. So, yeah, the first thing I wanted to talk about is the 3 points we found very, very interesting. Based on the AdLit project and also another study that is mentioned in the G29 Working Party Guidelines on Profiling, which is a new study on the impact of marketing through social media, online games, and mobile application on children behavior. You can find it on the internet. The 3 points we really find interesting is the first one, that children have grown in a digital environment, meaning that they are surrounded by digital devices such as mobile phone, laptops, and tablet, and they use it indistinctly. The second point, which is very important to us, is that technology development makes it easier for advertisers to target children because they have a lot of devices to use and media to use to target them. the fact that it's generally assumed that children are strong internet users and earlier adopters of new technologies and media practice. The third point, which is really important to us, and this have huge impact regarding data protection and the rules on data protection, is the fact that, and you just mentioned it, Simone, the lines between advertising and entertainment have become increasingly blurred. This means that it's not always clear for children to see that the program contains advertising or is the advertising itself. And this is really important for us. This has huge consequences regarding data protection. The second thing I wanted to talk about is, if it's okay to change, right, okay. So it's to come back to the GDPR. And the thing that I wanted to mention as well is really important for us is that we follow the trends regarding the advertisement techniques and so on within the Privacy Commission. But we have a kind of general policy regarding marketing which is indistinctly applicable to children or adults. And you see that in the GDPR it's practically the same, because you just mentioned that children are not specifically mentioned in Article 22, but we'll see that. So you just mentioned that the recital 38 of the GDPR mentioned that children merits a specific attention, especially for the use of their data for marketing purposes or creating user profiles. And it's true that when a child gives his or her personal data, such as an email address, hobbies, information about what they like, what they do not like, picture, whatever. Actually, they may not realize that those data will be used to market them. And as you just mentioned, they even don't know what is a marketing technique or what is marketing in general. So this is also why the Recital 38 just mentioned that they merit specific attention. As you just mentioned, the G29 Working Party takes the position that you are not necessarily prevented from using children's personal data for marketing purposes, but you need to make sure that you meet all the requirements under the GDPR. And this is confirmed, as you just mentioned, Simone, by the Article 22 of the GDPR, that makes no distinction as to whether the processing activities concern a child or an adult. It is also true that the Recital 71 makes a kind of a carve-out, saying that solely automated decision-making, including profiling, with legal or similarly significant effect, should not apply to children. Given that this wording is not reflected in the article of the GDPR, the G29 Working Party takes the position that this does not represent a prohibition, an absolute prohibition at least, on this type of processing in relation to children. And the public consultation is closed, so yeah. So and the guidelines on the profiling, automated decision making, which has a part on children, will probably be adopted in the plenary of February. It's in the beginning of February, 6th and 7th February. And this position I just mentioned won't change, right? However, in the light of this recital, the G29 Working Party recommends that wherever possible, controllers should not rely on this exception to justify the use of the children's data. The G29 Working Party takes the position that because children represent a more vulnerable groups of society, organizations should in general refrain from profiling them for marketing purposes. So you see it's a little bit more nuanced, that saying that it's not an absolute prohibition. As you mentioned it, Simone, the children have the same rights as adults in the GDPR, and one of those rights is the right to object to processing of their personal data for direct marketing purposes. And it's really important to inform them about that right. And I have to say that I don't know if everyone here knows the GPEN. Right, it's the global privacy enforcement group with a lot of enforcement authorities, which is a lot of data protection authorities, not in Europe, but also outside Europe. You have New Zealand, you have a lot of other countries, third countries, in this GPEN group, and they've made a study in 2015 regarding sites that are offering services and other things to children. And the conclusion is that information given on those sites is really, really bad. I mean, not in compliance with the law. And at that time, in 2015, it was the Directive 95, but now with the GDPR, probably that those sites won't be compliant as well. So I think there is a big work to do for information given to the children regarding the processing of their personal data. Regarding my last point on the enforcement thing, we think that enforcement in those kind of area will, and in general actually, will always remain a case-by-case analysis. And I have to mention that in addition, the new Privacy Commission, I don't know if everyone is aware of that here, our commission, Privacy Commission, will be restructured as we do not have any sanctioning power for now. So we have a law that has been passed by the government for a new structure, and probably that the new Privacy Commission could potentially decide to identify areas for enforcement and investigation. And as children data is one of the priority, probably this will have an effect on inspection plan. My last slide is about the redress and remedies for children and parents. As I already said, it's important to remember that children have the same rights as adults over their personal data. They can decide their own rights, they can exercise, their own rights as long as they are competent to do so. It depends on the national law. When the child is not considered to be competent, an adult with a parental responsibility could potentially exercise the child's data protection rights on their behalf. And the same reasoning is applicable for the remedy. So it means that they can complain to us, obviously, or another supervisory authority, depending where they are. Make an appeal against one of our decisions. Bring the legal proceedings against a controller or a processor. Claim compensation from the controller or processor for any damage suffered as a result of non-compliance with the GDPR. And last but not least, the Article 80 of the GDPR, which allows to make use of an association to act on their behalf. And this could also warn us that there is a problem in that area. So I think I'm done. Thank you.
Okay, thank you very much, Joëlle, for the Privacy Commission perspective. We will now move on to Patrick Geary from UNICEF. So Patrick, the floor is yours.
Thank you, and good morning. So as Valerie mentioned, I work on the Children's Rights and Business team at UNICEF. UNICEF has a long history of working with business, and over the past few years, this has taken on a new meaning as the notion of corporate responsibility for human rights has crystallized. So 6 years ago, UNICEF, along with, let's see if we can, there we go. UNICEF, along with Save the Children and the UN Global Compact, published the Children's Rights and Business Principles, which call on all businesses to respect and support children's rights in the workplace, marketplace, community, and environment. And in the marketplace context, the principles specifically address the issue of advertising and state that businesses should use marketing and advertising that respects and supports children's rights. So to help bring these principles into action, UNICEF has since published a set of general tools for companies to, among other things, integrate children's rights into their policies and codes of conduct, and also to conduct child rights impact assessments. And it is evident to us that collecting and processing children's data for the purposes of marketing and advertising implicates children's rights, including the rights to privacy, freedom of expression, access to information, and that companies throughout the advertising value chain have a responsibility to respect children's rights, and that in the online space, this often begins with children's data. So given the growing concerns around children's privacy, online, UNICEF published a discussion paper on the subject in late 2016 and launched an industry working group last January. From the outset, our goal with this work has been to have frank discussions around the role and responsibility of business and to come up with practical ways that companies can better respect children's right to privacy. There was strong support from this working group for UNICEF to develop guidelines on privacy and freedom of expression online. And following several rounds of consultation, for which we are grateful to some people in this room, I see some of the people in the group, and also Eva, who gave us some wonderful input. These guidelines have now transformed into general principles and an industry toolkit on children's online privacy and freedom of expression. So we are in the process of finalizing this work this month. For your background, the general principles are that, time delay. Children have the right to privacy and the protection of their personal data. Children have the right to freedom of expression and access to information from a diversity of sources. Children have the right not to be subjected to attacks on their reputation. Children's privacy and freedom of expression should be protected and respected in accordance with their evolving capacities. Children have the right to access remedies for violations and abuses of their rights to privacy and free expression and attacks on their reputation. And the industry toolkit that we have developed includes a checklist for companies to consider their impacts on children's privacy and expression rights online. Oh, here we go. With sets of questions that are grouped into 4 categories. There's obtaining children's personal data, using and retaining children's personal data, ensuring children's access to information, and educating and informing children online. The toolkit also includes background information and legal context for each of the questions that it asks, and it draws heavily from the GDPR and CAPA in the US. And it's our sincere hope that this will push companies to understand and think beyond the letter of the law and to make the links between data collection and the wider impacts on children's rights. So along these lines, the toolkit addresses marketing and advertising, and it asks some specific questions of companies, including, does your company use children's data to develop profiles for marketing purposes? Does your company target behavioral advertising to children? And does your company take steps to identify advertising or commercial content as such? Now, at the same time, UNICEF has been looking more directly at how digital marketing and advertising impact children's rights. We completed a worldwide review of legal frameworks on marketing and advertising in 2016 with our pro bono law firm partner, DLA Piper, and we found substantial gaps in the digital environment. We've shared this report widely within the industry, and we're now preparing to publish a discussion paper on children and digital marketing, tentatively entitled Children in Digital Marketing, Rights, Risks, and Responsibilities. And this paper will explore the implications of marketing and advertising for children's rights in a digital world. It will clarify the roles and responsibilities of marketing actors across the advertising value chain, and it will identify meaningful opportunities for change. Now, it does note a number of serious concerns about the use of children's personal data for advertising and marketing that include the fact that younger children likely lack the capacity to provide informed consent for the processing of their personal data, and that many parents do not have sufficient levels of digital literacy to protect the privacy rights of their children. We also note that older children struggle to understand privacy policies in terms of service. Much less are they able to appreciate the full implications of data collection. And we note that requests for data from children are increasingly invasive, seeking access to sensitive information like photographs and video footage. So from advertisers and ad agencies to data brokers, ad networks, and publishers, we have found that every actor across the digital marketing value chain uses children's personal data. They might obtain this data directly from children themselves or from observing children's behavior online. They might, sorry. Apologies. Didn't get your computer. Through data brokers or data management platforms, or they might pair offline purchasing or location records. Oh, you got me back. With online tracking. And last year, we convened a meeting with companies from different parts of the digital marketing value chain. And we're now thinking about how we can work with some of these to look more closely at how they can shape their use of children's personal data in marketing and advertising to avoid potential risks and negative impacts. Some of the themes that we might focus on are looking at the development of ecosystem-wide standards that create shared responsibility, better enforcement through accountability mechanisms, and increased transparency and information sharing. Just taking a quick look at the GDPR itself. So the GDPR promises a huge leap forward in the protection of children's data protection. Although, as we know, it leaves many questions unanswered. And it's important not to consider children's right to privacy in isolation, but also to understand how taking steps to protect children's privacy could affect their access to and experiences in the digital world. At the same time, we know that children's rights are not a zero-sum game, and it's possible to create an environment online in which children are both better protected and more empowered to exercise their rights. And we need to recognize that while digital and advertising literacy are key components of education, both for children and for parents, these do not displace the responsibilities of policymakers, businesses, and other actors to respect, protect, and realize children's rights online. And just to finally say that regulatory standards like the GDPR are just one piece of the puzzle when it comes to digital marketing and advertising to children. Things we might also want to consider are advertising codes and standards like the ICC, standard-setting projects like have existed with brands in the food and beverage area, and industry initiatives in particular elements and practices, looking at things like self-regulatory principles for online behavioral advertising from the Digital Advertising Alliance. So all this said, we look forward to continuing to explore the intersection between data protection, advertising, and children's rights further, and we are very eager to see how this changes as the GDPR is implemented both here in Europe and as the ripple effects spread around the world. So thank you.
Thank you very much, Patrick. I think we are all looking forward to the working paper. I will now pass the floor to Max from Lego, one of the companies that is most known by children, I think. So we're looking forward to hearing your perspective.
Thank you, but I'm not sure I actually dare say anything with this panel. We, of course, are one of the industry leaders with digital engagement towards children. Just listening to all my panelists, I have to start with a remark in saying not all marketing towards children are bad, but there is, of course, marketing that is too intrusive and harmful. But it seems like to be a general topic that marketing is perceived as bad. We do not share that opinion, just to be very open and honest. All right. I would like to start by talking about how we go about ensuring that children are not harmed when collecting their data. And with the GDPR soon coming into full effect, and what we chose was back in 2014 was to start a process of becoming BCR compliant through the Danish and French authorities. And that was us building on our values of caring and quality. We are a company with almost, soon 86 years of continuous growth, but with a value set on our physical products that we are wanting to be industry leaders in safety. We do not want to see children get harmed. And with the BCR and us becoming COPPA compliant, that was us taking the same step, but just into the digital world and ensuring children's safety. For all companies, GDPR is definitely a challenge. It's a mindset change with a lot of IT people that make sure our infrastructure operates on a daily basis. But also for marketeers, it's a huge challenge. Having to collect parental consent, informing parents, etc. And from a marketing perspective, it's often seen as a barrier towards interacting with children. We are seeing that a lack of good engagement and information leads to drop-offs when engaging with children. So it is definitely a challenge. I'll come back to more on that topic. But basically what we are trying to do with the BCR is finalizing the implementation to become GDPR, of course, and updating from what comes out from the Article 29 group, especially on transparency. So that is how we try and go about GDPR. I must say, as a personal remark, it requires top management buy-in, because you have to go through all value chains in the company from the beginning to the end. It touches upon so many business units, and it's a massive investment. All right. Being cautious of time, what we do in the Leiden group when we want to go out and engage with children is us building a new platform, and we have launched it in last January, and it's a platform that is being developed on all the time. It's not perfect yet, we're getting there, but it's a platform that is a safe social experience for children, where we are not pushing products, but where we are focusing on the digital play and learning through play. As I said, it is developing as we go along. We've launched into 26 countries now, and we are continuously doing focus groups test with parents, with children, with them combined, to actually make sure what works and what does not work. And we are also looking very, very interested in the short reports coming out of AdLit and UNICEF, 200 pages plus. And looking at those findings, and I think one finding that we also had is that wording in consent is so pivotal in getting parents to actually move on to the next step, and that's really a challenge, wording it so it on the one side seems very delicate, but on the other side is sufficiently informative and lives up to legal requirements. Just try writing profiling in a consent, that is not good. The app or the platform, we have it as an app, but also as one of our website offerings. It's simply where you can go in, you can get an avatar, your nickname or username is anonymous. There's nothing in there that will identify you towards somebody in the public. So we are the only ones who know who it is. We have pre-moderation on everything in real time. We do not allow pictures to being uploaded because we don't have any verifiable parental consent mechanisms in place as of yet. So we're basing our consent on the email plus system, as you might recognize from the US under the COPPA rules. So it is fairly low risk when it comes to privacy, or fairly low intrusive. Children can build, they can comment on the different pages in there, but in an emoji language we have developed using our own minifigure. So it's safe and it's very pure, and it is actually being very well recognized throughout the industry. But we are still battling with other social media platforms that is giving more space to children, also from my perspective, in a non-compliant way. But we are trying to build something that is valuable. And what we are investing in now is more engagement with parents, because we really recognize that parents has to be the driver of their children's behavior. Just like you send your kids out into the traffic, the parents has to be the one guarding the children in a regulated environment. And that's what we are trying to do with having the parents sit down with the children and helping educate the children on how to become future digital citizens. That's how we would like this to pan out, and also recognizing that the parents are the main responsibles for their children's behavior. That's it.
Okay, thank you very much, Max. Before opening up the floor for the public for questions to our panel members, there's one thing that I would like to put to the panelists, a question, something that we haven't really touched upon, but something that is the cause for a lot of debate on this issue. And that is the fact that up until now we have been talking about children. If we look at the definition in the United Nations Convention on the Rights of a child is anyone between the age of 0 and 18. In the GDPR, we don't have a definition of a child. So one of the questions that has been raised also reflecting what has happened in the US, where Kathy and Jeff have also been advocating for different rules, different approaches for younger children and adolescents. So I would like to know from the panel, do you feel that this is something that needs to be done? Do we need to do data controllers need to adopt different practices towards younger children and older children because they have a different maturity, because they have different capacities? So I would like to hear your perspective from your own point of view on this question. Simone, do you want to go first?
Yeah, of course. Well, I think certain parts of the GDPR do certainly, I think, require to take into account ages when it comes, for instance, to awareness and information. It will depend very much on the age of the child, what will work and what won't work. To get back to your to not having a definition, my statement there would be that where the GDPR doesn't mention age, like in Article 8, which is actually the only article that mentions age, is that we should use the generally accepted definition of the UN Convention of the Rights of the Child, which is under 18. And I think it was the ICO guidelines, the draft guidelines that have been published on how to interpret the GDPR in case of children. In one of their issues, and I think it was on profiling, they also mentioned the age of 18 and above, you know, as sort of the age where you differentiate. So certainly I think age can be an issue, and maybe not just with information, but also privacy by design, privacy impact assessment. So there might be other topics where you need to take into account what maturity children have. And I think we should start from what we should have as a starting point, that children are people under 18, and that also counts for the GDPR.
Okay, thank you. Joëlle, do you want to
Yeah, I
chip
think
in?
you just resume perfectly what I think, but I think that in the GDPR, it's true that there are only one article that is mentioning a difference for a child and adults, and this article, Article 8, is really specific because the conditions for application, as you just mentioned, are really strict. You have to be in information society services, but also you have to be based on consent or contract. So, and I think that the fact that we have a reciter which generally covers all the GDPR, because it's in the beginning of the reciter which is applicable to, it's the first reciter that covers almost everything in the GDPR, that says that we have to protect children, means that it has to be a preoccupation that is a general one. And it's true that regarding children and adolescents, I think that really they have a different way of perceiving the information and also different needs. So probably that there is also something to do there to, in our perspective, is also really linked to the information given, because it's really important that they know exactly what marketers do with their data. So I think that information could be different as soon as you have a children or an adolescent. So yes. And for the general one, I would support the idea to take into account the 18 age for children.
Okay, Patrick, you mentioned something about younger children and adolescents in your talk.
I did, and I would second these comments as well. And certainly, your point that at least under the Convention on the Rights of the Child, we would view at UNICEF children as all people under the age of 18. I think a key notion here is really on the idea of evolving capacities, which is also discussed in the Convention, and that children are able to exercise their rights in conjunction with their evolving capacities. So if we look at something like age of consent, where we've decided, or member states here in the EU will decide between 13 and 16 when a child can give informed consent, it's not as though magically on a child's 13th birthday something will change and a light will go on over their head. They will decide, okay, now I understand what consent means, or that light will go on at 13 in the UK and at 16 in France. So I think what we're actually, age is a proxy for looking at evolving capacities and for children's levels of understanding and maturity. I think that's really what's the most important thing to consider. And as long as there are differences in how understanding of data protection and understanding of marketing and advertising commercial intent are, I think those differences sort of occur along a spectrum from younger into older. So I think at no point is it not going to be a relevant consideration, but I think that you will see different levels of comprehension and understanding as a general rule between younger children and older children. It's just a matter of understanding what are those levels of comprehension and how do they play out with specific techniques, because you might have, in the case of marketing and advertising, you might have a commercial on TV that's easily recognized as commercial intent, but if it's a virtual reality experience, you might have teenagers who don't recognize this as commercial intent. So it's really interesting to see how that plays out. So for me, age is sort of it's almost like it's a red herring, but it's something that's a flag for us to sort of correspond with children's levels of understanding.
Max, I assume the target audience of Lego is, in any case, the younger children. Do you differentiate? No, from 0 to 99. But do you, in the practice, differentiate between ages?
Yes, definitely we do, and it's been a legal requirement in marketing for decades not to mislead, and that also focuses on the marketeer to actually being clear in their communication, taking into account who's their audience, which also means that you should design your communication so it's understandable and not misleading by the target audience who receives it. And if you look at the Article 29 group, what their answer was on transparency, they also highlight the same, design it for your audience. And I think that the challenge here is designing something that is actually understandable for children and also parents, to be honest, because just trying explaining profiling and the mechanisms behind that, or that the marketing mechanisms that we know of, just trying to explain tracking, going to from just a simple cookie, third-party cookie consent, going to Facebook, and how that machine operates. It's very difficult for a lot of people to understand. Just trying and giving transparency around that is very difficult. And when you then come to children, their parents, we face the challenge that you might be able to explain it, but they might not want to take the time to read it. So.
Yes. Okay, so a lot of challenges around transparency and information. Anyone from the public who has questions for our audience? Yes, please. There are mics, yes.
Can you hear me? I just wanted to ask a question continuing the theme around age. So obviously we've talked about the fact that different member states will be able to, are in the process of deciding whether they will have the age between 13 and 16 for parental consent. And the recent Working Party 29 guidelines sort of indicate that it's not 100% clear yet whether that age will be decided based on the place of establishment of the company or the location of the data subject. I just wondered what your thoughts are on that, and what your advice would be to companies who are trying to navigate this in preparation for May.
Okay. Is there a specific panel member you want to address, or no? Simone, you want to?
Yes, well, how they need to navigate that, I think it's going to be a challenge for them. So I would be interested to hear how they're going to do that. But maybe take a step back, because it's still in many countries not decided what the private international rule is going to be for this matter. And when we're looking at what, in the spirit of the GDPR, we would like to protect the data subject. So mostly in line with that, in my opinion, would be that you take the place of residence of the data subject. That's also an applicable law rule that we have in consumer protection law, obviously. And it would also be, I think, desirable here from the perspective of the data subject. Obviously, the perspective of the business is different. For them, it would be much more, it would be very helpful if they could have, the law of the place of business as the harmonized rule in the European Union. But I think that would not be so much in spirit with the GDPR and the protection that it aims to provide to data subjects. So. But as we see now, there probably will be different rules all across Europe. So that's going to be a challenge. Yeah.
Okay. Yes.
If I may,
Yes.
I just want to add something about that question. It's funny because the specificity in Article 8. The first thing I wanted to say is that pay attention, because we see a tendency using the requirement of Article 8 to any processing, which is not the case. We see that tendency, and this is really a problem for us, because it's not applicable to all processing activities. It's only applicable to processing activities that meet the requirement of Article 8. So this is really important for us to mention. The second thing I wanted to say is that the opening that is in Article 8, and that's what is funny, is that it has been asked by the industry. At the first draft for the trilogues for the Article 8, there were no opening clauses. It has been required by the industry. And now the problem is that industry will have problems to implement it. True. So I really think that we will have problem for implementation, and marketers will have huge problems for implementing that particular thing. But I wanted to insist on the fact that the Belgian Privacy Commission really urge other countries to find an harmonized approach. We really ask for it. The thing is that you have to bear in mind that when member states have to find a compromise, it's like really, really difficult, because everyone wants to protect their own data subject. So they wanted to have their own law or rule, you see? And finding a common one is not really easy.
Yeah.
Thank you.
It will be a huge challenge. One question we have time
Chair.
for is Jeff.
Well,
Yes.
I know the time is. It's an excellent panel. Some of you may know that Catherine Montgomery and I led the effort that created COP in 1998 and created the rules in 2012, which are cross-device rules, which we actually based on the directive and the good work here. And in terms of enforcement, EU and US NGOs, by the way, intend to strongly enforce the GDPR in terms of children and teenagers, and you will see multiple filings after May 25th. But let me just ask you in terms of enforcement, and you already discussed it. To what extent do the DPAs need to understand the design, the construction of contemporary media, where the marketing, as you were saying, Yves, where the marketing applications and the data collection are intertwined? You're talking about programmatic and AI and VR and an immersive environment purposely designed on a cross-device basis, right, to encourage the child and, frankly, the parent, right, who is often a target here to get the child to agree. How do you think how will the enforcement agencies and how should the enforcement agencies examine the contemporary dimensions of digital marketing in order to ensure that minors are well protected?
Well, I think it's really important that we have an idea about how new techniques are working, because otherwise we cannot see what is the impact on data protection on those techniques, obviously. But I'm not sure that we need to have, an in-depth knowing on how it. Otherwise, we have to do it for all other issues, which is not possible. But the thing is that we really need to follow the trend to know what it is, what trend is going on, and probably have some notion on how it works to make sure we can see how personal data are processed and how we can enforce the principle of the GDPR. Yes.
I saw one more person standing up. Please keep the question brief.
Yeah, I think I can keep it brief. Timo Veldman, Defense for Children. Just have a question for Simone. You rightly said it contains both protection and empowerment articles, just as is the case most of the times when it comes to children's rights. And I was just wondering if you think it's balanced, the GDPR, when it comes to, or does it go one way? Is it too much protection, for example?
Children themselves would say yes. It's well, it's not balanced. Let's say that. So there was a very short or a small study in the Netherlands very recently, where children were asked what they thought about the GDPR. And they claimed that it's a violation of their right to privacy in their relation with their parents because of Article 8. Well, of course, fortunately, it doesn't apply in all cases, but that was something that they felt very strongly. Although they also felt very strongly about getting advice from parents as something that is important, but they also said it's a violation of our privacy. And it may also be a violation of our right to information. Because platforms may be banning children because of the stronger data protection that they're getting. So they themselves say that it focuses too much on protection and that freedom rights, but also development rights, because empowerment is about both, should have taken more into account. And I endorse that completely. Okay.
Yeah. So you agree?
But I won't say that protection isn't important, of course. It is, but there should be more of a balance. And I'm a bit afraid, yes, that because of this stronger protection for children, that they will miss out on platforms that might actually be important to them. And it's also a trend that we already see to a certain extent. So that may be a negative implication of the GDPR that we don't want, I think.
Yeah. Thank you.
Maybe just to add to that, one of the issues is also that there is a strong feeling that many of the decisions that have been made have not been based on evidence. There is a lot of research already on how children use the internet, but specifically for data collection practices and how children understand these practices, how they cope, how they adopt certain strategies, is something that a lot more research needs to be done. And I think that is also an important element to base future decisions on by companies, by DPAs, by different actors. It's a little bit for our own benefit. We always need to do more research at universities, but we really feel that the policy making also in this area really needs to be evidence-based. Please join me in thanking our excellent panel, Simone van der Hof, Joëlle Jouret, Patrick Geary and Max Sørensen, and enjoy the coffee break.